welcome to this function on Ambedkar Jayanti. I would like to first welcome Honorable Justice B.R. Gavai and Honorable Justice Abhay S for agreeing to be a part of this event. I would also like to welcome all the judges of the Honorable Supreme Court in our midst, as well as the Honorable judges of the Delhi High Court, past and present. And future. I stand corrected. Yes, ma'am, I'm coming to them. And all the other honorable judges in our midst, as well as senior advocates, lawyers, journalists, students, ladies and gentlemen. We have gathered today to commemorate an exceptional human being and intellectual who needs no introduction, Dr. B.R. Ambedkar. Born into the Mahar caste, Dr. Ambedkar overcame adversities throughout his life to not only give India its constitution, but also abolish untouchability and incorporate affirmative action firmly into our constitution. Dr. Ambedkar was a true Democrat. As the chairman of the drafting committee, he dealt with diverse ideas of his colleagues in finalizing the Indian Constitution and enabled all perspectives to be discussed and debated, even when he did not agree. He possibly drafted the whole of the preamble and was responsible for inserting fraternity as a prerequisite for liberty and equality in the Constitution, which is a very, very compelling idea, as Dr. Ambedkar believed that liberty, equality, and freedom were not possible without fraternity. I want to now quote from Dr. Ambedkar himself on what he thought and believed about fraternity. What is your ideal society if you do not want caste, he asked. If you ask me, my ideal would be a society based on liberty, equality, and fraternity. But what do these words really mean? An ideal society should be mobile, should be full of channels for conveying and change taking place in one part to other parts. In an ideal society, there should be many interests consciously communicated and shared. There should be varied and free points of contact with other modes of association. In other words, and I find this extremely compelling when he said that there must be social endosmosis. What a beautiful way to describe exchange of ideas and diversity that our country truly represents today. This is fraternity, which is only other name for democracy. Since he was a true Democrat, he saw everything in the prism of democracy. Democracy is not merely a form of government, he maintained. It is primarily a mode of associated living, of conjoint communicated experience. It is essentially an attitude, and I emphasize this, it is essentially an attitude of respect and reverence towards fellow men. What can be more democratic than what Dr. Ambedkar thought and conceptualized? Of course, Article 32, which is the topic for discussion today, was described by Dr. Ambedkar himself as the heart and soul of the Indian Constitution. Without further ado, I would like to start the proceedings of the evening by inviting Ms. Indira Jaising, who is another person who needs no introduction. But I may just add that she is someone who has broken every single glass ceiling that was possible for women lawyers, and was not only the first woman additional Solicitor General of India, but also represented India at very senior levels at the CEDAW committee at international levels. And I need not say more, but may I please invite Ms. Jaising to start.
Thank you, Warisha. A a warm welcome to our honorable guests over here, each and every one of you. My task here is to just make a few opening comments and hand over to the speakers. So we are gathered here today under the auspices of the Leaflet, which is the digital legal news and opinions magazine, and of course the Society for Constitution and Social Democracy, represented by Dr. Chauhan, who is sitting here on the dais with you and who will be speaking a few words to you also. It's the 133rd birth anniversary of Dr. Ambedkar. The leaflet itself has a tagline, Constitution First. It was founded in 2018. You will hear a little more about it from our editor, Arif, who will be speaking to you. One of the activities which we want to encourage is a healthy dialogue between the bar and the bench, where we can understand each other better outside the framework of a courtroom. There is much to discuss outside the framework of the courtroom. And this is one such occasion. This is the reason why we have chosen Article 32, its history and future, for discussion today. We've requested both the speakers to address this issue. In my opinion, we stand at a moment of cusp in this country today, where history and future will be made, and we want to focus on the present. What is it that we can do today to preserve the legacy of Dr. Ambedkar? Now, it is the only constitution in the world which has direct access to the Supreme Court. There's no other constitution in the world which has a guaranteed fundamental right as access to the Supreme Court. So we are justly proud of this constitution. We also believe that Article 32 is not what is commonly called, quote unquote, a prerogative writ, which is what the writs of the courts in England were referred to. What is the distinction between Article 32 and the writs that the English courts were issuing? These are not prerogative writs, because 32 is a guaranteed fundamental right, and we certainly would like the two judges present to address that issue. What does this distinction mean for us? Now, the Constitution is unique in the world. Unique in the world. It's attempted a peaceful transformation of a country which was ridden by inequality, ridden by poverty, ridden by ignorance, but it attempts a peaceful transformation from that to a situation of equality of opportunity and equality before law. I am not aware of any other country which has attempted this kind of constitutional transformation. This is what I mean when I talk about transformative constitutionalism. Now, it is a constitution that has held together diverse groups of people, diverse religions, diverse languages, diverse cultures, diverse beliefs, held all together by just one thing, the Constitution of India. What makes us into a nation is this Constitution. That is my belief. And that is why we stand committed to the protection of this Constitution. I'm going to end on a very personal note. I am a refugee from across the border. There is no state in India called Sindh. So I'm sometimes flummoxed when people ask me the question, where are you from, Ms. Jaising? I don't have an answer to that question because Sindh has no homeland in India. So where am I from? That's the question I need to ask myself on a daily basis. And the answer that I have received is, my home is the Constitution of India. I live under the kavach. I live under the kavach of the Constitution of India. As a woman, I can say this, that what did Dr. Ambedkar give to me? I ask myself this question every day. What he gave to me is the right to work as a woman. I come from a very conservative family where no woman ever worked, but I did. And I did it because I got this right from the Constitution of India. I got the right to move freely throughout the territory of India, which is why I migrated from my hometown where I was born, that is Bombay, to Delhi, then known as Bombay. I got the right to non-discrimination based on sex. All this was the gift of Dr. Ambedkar to me, and I exercise it on a daily basis in any court, everywhere, everywhere. So it is Article 15 of the Constitution that has been my protection. It has protected me from the arbitrary action of the state. As I said, it's enabled me to exercise all these rights. However, I'm going to end on a problematic note. I believe that Article 15 awaits a definitive interpretation at the hands of the Supreme Court of India. We still don't have it. And why is that? It is because the article says no person shall be discriminated against based on sex, caste, race, religion, or any one of them alone. Emphasis on the word alone. This is the most misused word, a mischievous word in the hands of jurists. And they have repeatedly said, yes, you're discriminated, but not on the basis of sex alone. In what has come to be known as the Nargish Mirza case, this is what the Supreme Court said. It said, yes, women have to resign on marriage, but not men. However, this is not discrimination based on sex alone. This is, I'll leave you with the thought, this is the unresolved question hanging in the air for the Supreme Court of India to resolve. And it's common across the board. You are discriminated against because you're a Dalit, but not on the ground that you're a Dalit alone. I would like to ask the question, does discrimination ever come as a standalone gift? No, it doesn't. It comes along with misuse of power. It comes in a hierarchical situation. And that dismantling of hierarchy is what we call the right to equality. Thank you very much.
Thank you, ma'am. I would now like to invite Arif Ayaz Parrey, who's the editor-in-chief of the Leaflet, to talk about the Leaflet.
Thank you, Warisha. Honorable members of the bench and the bar, colleagues in the media, friends. In the blink of an eye, the Leaflet has turned 6. And we would like to believe that in these 6 years, we have done some good work. We still have the energy of every 6-year-old, which is what is needed in the defense of free speech, I guess. Interestingly, our very name itself, the name under which we have registered ourselves, it contains 191A, AGIG, promotion of 191A Private Limited. The energy is needed because independent journalism of the kind of which we are a small part is under a great threat today. Our story is the story of every independent media organization. I think it will resonate with a lot of friends in the media today. As the poet has said, इस राह में जो सब पे गुजरती है वही हम पे भी गुजरी. On the supply side, which is like producing media, producing content, whenever we have to discuss a story in the newsroom, we go beyond the questions of whether a story has a good angle, it has a good peg, it is relevant, it is timely, and now we have to think about whether that particular story will land us in trouble. I can't tell you how many times I have had to reassure my young reporters that a particular story they are working on will not land them in jail. And these are not unfounded fears. We know how many journalists have been arrested for flimsiest of grounds and then incarcerated for unbearably long periods of time. What this ends up in is self-censorship. And self-censorship shifts the epistemes in the society, whereby a new paradigm of truth becomes mainstream, and truths which some of us hold dear to us, truths which might be the basic structure of our lives. They are sidelined, marginalized, criminalized. What this self-censorship also ends up doing is ensuring that the social inequity within our industry, within the media industry, is perpetuated into the next generations. Because when you raise the cost of telling the truth, men and women from marginalized communities cannot risk truth telling. So the media, even the best of the media, continues to be dominated by the privileged. On the demand side, which is people consuming the media, you know that digital platforms like us are completely dependent on views. Even the ads we get are connected to that magical number. But views are a very mercurial overload. For example, in the last 1 year, the stories, our stories, which have received the most number of hits, have been stories which somehow show the judiciary in a unflattering light. The great poet Allama Iqbal, he wrote, जमहूरियत एक तर्ज हुकूमत है जिसमें बंदों को गिना जाता है तोला नहीं जाता, which is that democracy is a system of government where people are counted and not weighed. Incidentally, calling Iqbal great is already a controversial topic in India, and it might in some years become illegal, which is the kind of shifting of extremes I was alluding to earlier. So there's a great, among the average reader, there's a great desire to see the judiciary reduced to a vaudeville show. Maybe this impulse comes from the same psychosis which wants India to be ruled by a dictator. Perhaps in the era of Instagram Reels, in the era of YouTube Shorts, all content, even content about serious judicial matters, is just entertainment. We have a conscious policy at Leaflet to avoid indulging our readers on these base instincts. The only time we highlight judicial controversies is when we think that they will help further the debate on accountability. For example, when Justice Kaul, just after his retirement, he had a few things to say about the roster in the registry. But this absistence from sensationalism, this costs us overall lives, and that is a challenge for our finances. In the short term, a support for, like your support for media organizations like ours can help us stay afloat. And a more proactive judiciary whereby the bugbear of national security is taken off, freedom of speech and expression and the freedom of press. And journalists are allowed judicial remedies quicker and more easily. That might help sustain independent media in India. But in the long run, this epistemological fight will need a more substantial response. And that's the thought I leave with you.
Thank you, Arif. I would now like to invite Sunil Kumar, Senior Advocate, to talk very briefly about Article 32 and the importance to the backward classes.
Greeting and very good evening to everyone. On behalf of the Society for Constitution and Social Democracy, may I start by delving into the real meaning of democracy, which is not only for confined to giving votes in an election. Giving votes in an election is a major part of the democratic functioning. But however, it is not the only part, as per the Dr. Ambedkar. The Honorable Supreme Court in the recent elective bond judgment observed that the preamble to the Constitution described India as a democratic republic, a democracy in which citizens are guaranteed political equality irrespective of caste and class, and where the value of every vote is equal. The democracy does not begin and end with the elections. Dr. B.R. Ambedkar, speaking into the Constituent Assembly on 25th November 1949, has stated in his famous last speech that we must make our political democracy a social democracy as well. Political democracy cannot last unless there lies at the base of it social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity as the principle of life. Furthermore, Dr. Ambedkar said that there is a complete absence of two things in society. One of these is equality. On the social plane, we have in India a social society based on the principle of grading. Inequality, which we have a society in which there are some who have immense wealth as against many who lives in abject poverty. On the on the 26th January 1950, we are going to enter into a life of contradictions. In politics, we will have the equality, and in social and economic life, we will have inequality. How long shall we continue to deny equality in our social and economic life? If we continue to deny it for a long, we will do so only by putting our political democracy in peril. Friends, this independence has given us, the citizen, a huge task of making this nation a social democracy from a political democracy, where each person, despite what he earns, what he learns, where he is born, gets the same respect and status, that is equality of status and of opportunity, as mentioned in our preamble. Therefore, we at the Society for Constitution and Social Democracy endeavor to abolish this system of grading inequality and establish equality, liberty, and fraternity. That is an egalitarian social order among all citizens through constitutional means. We believe that we must leave all other false identities and come under one identity, making India Dr. Ambedkar society democracy in its true sense. As Dr. Ambedkar said, we are Indian firstly and lastly. Thanks to everyone.
I apologize for hurrying up the speakers, and it's not very democratic, but I'm duty bound, so please forgive me. Thank you, Dr. Sunil Kumar. I will now invite Dr. K.S. Chauhan to talk about Article 32 briefly. Please, sir.
Greetings and a very good evening to everyone. First of all, I thank Honorable Justice B.R. Gavai and Honorable Justice Abhay S, along with all dignitaries on and off the dais, particularly Justice K.V. Viswanathan, Justice Ravinder Bhatt, Justice Sakdar, Justice Varale, Justice Bhoyan, and after all, at this age, Mr. Murli Bhandare, he was a leading senior advocate and former governor of Odisha. So, I I thank everyone for joining this melody. As we are here to listen to Dr. Ambedkar Memorial Lecture from two distinguished honorable judges of the Honorable Supreme Court, and I am asked to dwell upon the topic of Article 32 and the importance to the backward classes. I must begin by saying that what does independent India establishing a country based on rule of law and democratic principles mean to the backward classes? That is, whether they are scheduled caste, they are scheduled tribe, they are other backward classes, or the religious minorities and even the women. Because according to my perception, they fall in the backward classes category. Historically, starting from the American Revolution, which gave us the well-recognized principle, no taxation without representation. When the American objected to the imposition of taxes on colonists by a government that gave them no role in its policies. Therefore, historically, it is seen that the ultimate objective of independence of a country is to vest the functioning of the country in the hand of its citizen. In other words, to give full representation to the citizen in managing the functioning of their country. That's why Dr. Ambedkar on 25th November 1949 has stated, and I quote, "These downtrodden classes are tired of being governed. They are impatient to govern themselves." And in the same line, Dr. Ambedkar has further said, "Therefore, the sooner room is made for the realization of their aspiration, the better for the few, the better for the country, the better for the maintenance of its independence, and the better for the continuance of its democratic structure." Dr. Babasaheb Ambedkar's broadcast from All India Radio, he has stated that the principle of self-governance, government expresses the desire of the people to rule itself rather than to be ruled by others, whether the rulers be absolute monarch, the dictators, and the privileged classes. It is called democracy. This is, I am quoting from Babasaheb's book, that is volume 10 and page 39. Dr. Ambedkar argued that democracy should ensure representation of opinion and representation of persons. Hence, to ensure that we move to an egalitarian social order, our constitution makers did not only recognize formal equality but also real equality by introducing reservation for the marginalized section of the society to ensure their participation in affairs of our country. We are going to celebrate 77th years of our independence. The question we should ask is that these years, whether there have been, we have been able to ensure representation of these marginalized sections in the functioning of our country, whether that is the judiciary, the media, in jobs, especially in the upper echelon of the administration. To ensure the same, there should be a department-wise continuing mandamus wherein the court should monitor to ensure the adequate representation of marginalized communities in the institutions. For true equality, judicial review should not restrict reservation policies. Rather, it should act as a medium for effective enforcement of the same. Another tendency of the courts these days is to refer to the reservation policy as affirmative action, and it was referred here also. Nothing, noting them the sole discretion of the state whether to implement them or not. Whether this dictum itself, whereas this dictum itself is against the 9 judges bench decision in Indira Sani case, wherein Justice Jeevan Reddy, speaking for the majority, has held that Article 16.4 is not an exception to Article 16.1. It is an instance of classification inherent in Article 16.1, para 741, it is stated. Therefore, since the state cannot deny equality to any citizen, how can the state deny reservation, which is a facet of equality and not an exception to the same? Hence, the court, while exercising power of judicial review on being petitioned, are bound to implement reservation policies in such institutions, in various institutions where it is still not implemented, whether in letter or in spirit. We are discussing Article 32, that is the heart and soul of Indian Constitution, which implements the fundamental rights. By way of exercising judicial review, I would like to quote Dr. Ambedkar's book, State and Minorities, wherein he has said, "Ask those who are unemployed what are called fundamental rights, whether they are is my insertion of any value to them. If a person who is unemployed, is offered a choice between a job of some sort with some sort of wages, with no fixed hour of labor, and with an interdict on joining a union and the exercise of his right to freedom of speech, association, religion, etc., can there be any doubt as to what his choice will be. How can it be otherwise? The fear of starvation, the fear of losing a house, the fear of losing his saving if any he has, the fear of being compelled to take his children away from the school, the fear of being having to be burdened on public charity, the fear of having to be burdened or buried at the public cost are factors too strong to permit a man to stand out for his fundamental right. The unemployed are thus compelled to relinquish their fundamental right for the sake of securing the privilege of work and to subsist. Hence, friends, Dr. Ambedkar said on 15th March 1947 is true even today. We must think of ways to eliminate social and economic inequalities. Otherwise, the fruit of fundamental right will be restricted while reaching the masses. Thank you very much for the time today. Thank you.
Just one quick housekeeping announcement. We'll be taking questions after both the honorable judges have spoken on a piece of paper. So if you want to ask a question after their presentation, please put your name down. And if it is addressed to a particular judge, and you can pass around their volunteers on the side, and we will ask them at the end. Please, Mr. Jaideep Gupta, Senior Advocate, now will introduce our main guest for the evening, Justice Abhay S. And please.
Thank you, Warisha. I have the pleasant task of introducing our speakers here who need no introduction whatsoever to this audience. Justice Abhay S has had the experience of practicing in all courts from the lowest to the highest for 20 years and a judicial career spanning another 20 years. From this unique perspective, Justice Oak is in the best position to reflect on the progress of the law and the judiciary in this country for the last 75 years. Reflecting on the access to justice in the 75 years of the Constitution, Justice Oak has recently observed, what I can gather from my interaction with stakeholders is that the judiciary has not fulfilled the expectations of the common citizens of India. In my view, we must find out where we have gone wrong. Article 32 plays a crucial role in affording access to justice to the people of India. We therefore look forward to hearing from His Lordship on the article which guarantees access to the highest court to all persons in this country. Justice O.
Dignitaries on the dais and dignitaries of the dais, I must compliment the Leaflet and the Society for Constitution and Social Democracy for this debate on very important issues concerning Article 32 of the Constitution as a part of the Ambedkar Memorial Lecture Series. Supreme Court has described Article 32 as the cornerstone of the democratic edifice raised by the Constitution. This year is the 75th year of our Constitution, and this is the most appropriate time to revisit our Constitution. I am connected with some of the law schools and law colleges, and I have been insisting that this year there should be several programs in which we should have a debate on various constitutional subjects. I have been reading articles published on Leaflet. The articles are very well articulated. The articles contain constructive criticism of judicial approach or judgments of the court, which I always welcome. Second reason why I appreciate Leaflet is for initiatives like this, where in presence of very learned members of the bar, young law students and citizens, we are going to have debate over this important subject. There is one more reason why I appreciate Leaflet. That reason is Leaflet publishes those hilarious articles by my dear friend Raju More. In fact, when I occupied the stage, I was looking for that familiar face here, so that after a few days there will be very hilarious article on today's function. When Anand approached me to participate in this function, I accepted the invitation for more than one reason. The first reason is I can't say no to him. The second reason is I thought that this will be a great opportunity for me to hear constructive criticism about the judiciary and judicial approach. I accepted the invitation, and few days thereafter I realized how difficult it is going to be my task, because Anand forwarded to me a concept note in which 3 questions have been formulated. The questions, I read those questions, but I don't think that concept note has been circulated. There are 3 important questions formulated by Anand. The first is, under what circumstances does the Supreme Court entertain Article 32 petitions, and when not? Whereas when not is the most dangerous part of it. The second is, again very difficult, what are the differences between jurisdiction under Article 32 and Article 226 read with Section 482 of the Constitution of India? And third, and perhaps the most important, what explains the fact that the Supreme Court has entertained Article 32 petitions in some cases and not in other cases? This is the most difficult question of the 3. As a junior lawyer, I have seen when we used to argue second appeals before the High Court, and when we used to raise very difficult substantial questions of law under Section 100, there was some tendency to summarily dismiss those second appeals, because it was very difficult to answer those substantial questions of law. I don't have that choice today. I'll have to make an attempt to deal with these questions. If you look at these questions, at the first blush, the issues appear to be very simple. Obviously, someone will argue that on plain reading of Article 32(1), the questions framed will not arise at all, because Article 32 is a part of Chapter 3 containing fundamental rights. So it is a fundamental right to seek a remedy to enforce a fundamental right. So where is the question of any debate? It is so fundamental that, and it being part of part 3 of the Constitution, where is the debate? If a petition is filed before Supreme Court invoking jurisdiction under Article 32, it has to be dealt with on merits. And another reason is that Article 32 per se does not allow any embargo to be put on exercise of the jurisdiction. But in practical terms, when you start thinking more and more on these 3 questions, you will realize that it will be very difficult to clearly answer these 3 questions. I am not going to refer to many decisions of the Supreme Court, because I have to complete my task within 19 minutes assigned to me. Of course, first and foremost judgment when we think of Article 32 is that historic judgment of Romesh Thapar versus State of Madras, 1950 SCC 436, where it's a bench of 6 honorable judges, where we always read very erudite expressions by Justice Patanjali Shastri. And all of us know paragraph 4, but I'm reading it only for the benefit of young interns and law clerks who are present here in large numbers. What Justice Patanjali Shastri says is Article 32 provides a guaranteed remedy for the enforcement of those rights, And this remedial right is itself made a fundamental right by being included in Part 3. This court is thus constituted the protector and guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid upon it, refuse to entertain applications seeking protection against the infringement of fundamental rights. So this is the guiding principle for us, and this opinion is by a bench of 6 honorable judges. So in short, a distinction is made between Article 226 and Article 32. Basically, Article 226 is a power conferred on the high courts, but Article 32 entrusts a responsibility on the Supreme Court to become protector of fundamental rights. That's the perhaps distinction between the two jurisdictions. Another important decision authored by Justice P.B. Gajendra Gadkar is in the case of Premchand, Garg and another versus Excise Commissioner UP, that is 1962 SCC Online 37. In paragraph 2, he has succinctly covered the issue. I read only part of it. The court says, there is no doubt that right to move this court conferred on citizens of this country by Article 32 is itself a guaranteed right, and it holds the same place of pride in the Constitution as do the other provisions in respect of the citizens' fundamental right. The fundamental rights guaranteed by Part 3, which have been made justiciable, form the most outstanding and distinguishing feature of Indian Constitution. Then the bench further says, the Constitution makers thought it advisable to treat citizens' right to move this court for the enforcement of their fundamental rights as being a fundamental right by itself. The fundamental right to move this court can, therefore, be appropriately described as the cornerstone of the democratic edifice raised by the Constitution. So, Article 32 is taken to the highest pedestal by these two very important decisions. Interestingly, Justice Gajendra Gadkar notes a very unique argument advanced before the Supreme Court by a distinguished member of the bar. The argument was, the guaranteed right under Article 32 is absolutely absolute. Though in so many words, this argument is not accepted, but if you read the entire judgment, this argument that this guaranteed right being absolutely absolute is virtually accepted by this court. Perhaps the second question, somebody may say that these two judgments answer the first question. The second question is also attempted to be answered by Justice P.B. Gajendra Gadkar in the case of Daryao and others versus State of UP and others. That's 1961 judgment, 1961 SCC Online, page 21. The distinguished members who are present here, they must pardon me for not referring to neutral citations. Ideally, I should have been referring to neutral citations. In paragraph 23, Supreme Court clearly brings about distinction between the remedies under Article 226 and 227. And Supreme Court says that it is, however, necessary to add that in exercising its jurisdiction under Article 226 of the High Court, may sometimes refuse to issue an appropriate writ or order on the ground that the party applying for the writ is guilty of laches, and in that sense, the issue of a High Court prerogative writ may reasonably be treated as a matter of discretion. On the other hand, the right granted to citizens to move this court by appropriate proceedings under Article 32(1, being itself a fundamental right, this court ordinarily may have to issue an appropriate writ or order, provided it is shown that petitioner has a fundamental right which has been illegally or unconstitutionally contravened. And the court goes on to say that ordinarily, if a petitioner makes out a case for issue of an appropriate writ under Article 32, the court would not refuse that relief. So that's the distinction sought to be made out between two, perhaps the parallel remedies under Article 226 and 32. As I said, the decisions in the case of Romesh Thapar and Premchand may answer the first question. But really that answer may remain on paper. With these landmark pronouncements, which are very old and ancient, somebody can argue that Supreme Court must entertain each and every petition filed for enforcement of fundamental rights without relegating the petitioners to remedy before the High Court under Article 226. But I must say here that we are not living in an ideal world. If we are not facing the huge challenge of mounting arrears, perhaps this concept could have been followed in letter and spirit. But today we don't live in an ideal world. Our Supreme Court has pendency of cases over 80,000. And it is not merely a constitutional court, it's an appellate court. There are many distinguished members of the bar present here who practice before the Supreme Court. And all of them know that every Monday and Friday, about 25% of the cases which we deal with are SLPs filed against order refusing to grant bail. And we are not only appellate court while we deal with SLPs where relief of bail has been refused, but our duty is to act as constitutional court also. And therefore, we have to deal with these cases at the earliest and grant bail wherever the petitioners deserve to be granted bail. Today, if we see the cause list of every Wednesday and Thursday, we have 2008, 2009, 2010 appeals which are listed. I am party to several decisions in old criminal appeals where we had given acquittal to somebody who has undergone 10 years, 15 years, and even more. There are, of course, in our system, our legal system, there are victims also. There are cases of unmerited acquittal. There are SLPs and appeals lying in the Supreme Court, very old appeals against orders of acquittal, where there are cases of unmerited acquittal. There are service matters involving rights of workmen and laborers. There are matters coming from traditional civil courts, where a common man is fighting for 30 years to get a small share in a very small agricultural land. This is a situation which we face, which compels us to tell some of the litigants who invoke Article 32 to go to the high courts. The reason for this is that when we are facing mounting arrears, we have to fix our right priorities, or at least we have to make an attempt to fix correct priorities. There are two decisions about which there should be a debate, which make an attempt to lay down principles governing the exercise of jurisdiction under Article 32. Now, the first decision is in the case of P.N. Kumar versus Municipal Corporation of Delhi, that is 1987, for SCC 609. About 10 principles have been laid down by a bench of this court. And some of the, at least I'll read 3 out of 10. The first one is, our court says, if the cases which can be filed in the high courts are filed in the high court and not in this court, the task of this court of acting as an original court, which is a time-consuming process, can be avoided, and this court will also have the benefit of decision of the high court when it deals with an appeal filed against such decision. If the cases which may be filed in the high courts are filed in this court, it would affect the initiative of the high courts. We should preserve the dignity, majesty, and efficiency of the high courts. The taking over by this court of the work which the high courts can handle may undermine the capacity and efficiency of the high courts, and that should therefore be avoided. And then the last principle laid down is, the time saved by this court by not entertaining the cases which may be filed before the high courts can be utilized to dispose of old matters in which parties are crying for relief. And then comes one more decision, that is Kanubhai Brahmabhat versus State of Gujarat. It is 1989, supplementary to SCC 310. And that is where a bench of Apex Court says, the time for imposing self-discipline has already come, even if it involves shedding of some amount of institutional ego or raising some eyebrows. Again, it is an important to do justice at this level as to inspire the confidence in the litigants that justice will be meted out to them at the High Court level and other levels. Faith must be inspired in the hierarchy of courts and the institution as a whole, not only in this court alone. And this object can be achieved only by this court showing trust in the High Court by directing the litigants to approach the High Court in the first instance. And then it goes on to say that there will be a decision of the High Court which will be very handy for the Supreme Court. Now, these are the two decisions which of course call for a debate. Now, whether these decisions take a contrary view to what is held by the larger benches is a matter which will have to be debated upon by everyone. But ultimately, it will have to be decided by appropriate bench of the apex court. Dealing with question numbers 1 and 2, I must say one thing very categorically, which I have said repeatedly on public platforms. I have said that every citizen of this country has a right to offer constructive criticism of the judgments of the court. I always believe that constructive criticism of our judgments, of our approach, helps us to introspect. Therefore, somebody may surely criticize the view which is taken in the latter two judgments, which I have made a reference. And they can certainly say that these judgments run not only contrary to the judgments of the larger bench, but very language of Article 32(1). The third question raises a very valid and sensitive issue. The language used by Mr. Anand is different, but I'll translate that question into common man's language. The question is, why you are entertaining selected few cases and sending other cases to the high courts? That's the purport of the third question. And therefore, ultimately it means that every case under Article 32, where there is violation of fundamental rights, should be entertained. I remember about 6 months back, I had occasion to go to visit a law college and speak on the issue of 75 years of constitution. And there was a question and answer session. So I must share that my experience for last 20 years is some brilliant ideas we get from young law students. So one law student got up and he said, sir, there is a judgment of Justice Kuldeep Singh which says that every High Court and of course Supreme Court should have green bench. So why there should not be Article 32 specialized bench before in the Supreme Court? That was the question asked to me. Of course, I could give only one answer, that this question has to be posed to the Master of Procedure and not to me. But still, that was a very relevant question asked to me, that why there can't be a dedicated bench to hear 32 petitions. Now, coming back to third question, we have to see the practical aspects of it. There are a variety of fundamental rights. One fundamental right is under Article 19(1)(g), right to carry on trade or business. Tomorrow, one very rich and influential businessman, will come to the Supreme Court and will complain about violation of Article 19(1)(g). If there is a powerful businessman, I mean no offense to anybody, just in a lighter vein. If there is a powerful businessman, he will be naturally backed by a powerful team of lawyers who will argue at length and consume a lot of important time of the court. And he will say, sir, this is Article 32. My fundamental right under Article 19(1)(g) has been violated. And when all this happens, look at the plight of the other litigants. There are cases filed under Article 32 by prisoners who have been denied right of permanent remission under the policies of the various state governments. There are accused who have preferred appeals against the conviction and who have undergone more than a decade of incarceration. They will have to wait in the long queue. Can we allow the time required to be devoted, time which is actually required to be devoted to the deserving Article 32 cases, to be consumed by cases of businessmen? This is a question we should have to ask ourselves. As I said in the beginning, we don't live in an ideal world. We have to deal with arrears. We have to deal with huge filing of cases which is made before the Supreme Court. And therefore, while considering or debating upon the third question, this aspect will have to be considered. Because if we start giving priority to the cases of business houses where the allegation is that violation of Article 19(1)(g), questions will be raised about the priorities adopted by the Supreme Court. And in fact, this is the conflict which arises day in and day out in the mind of every judge of the Supreme Court. As done in these two cases which I invited your attention, there may be few people who will suggest that, why not lay down rational tests to decide in which cases petitions under Article 32 of the Constitution of India should be entertained. Somebody will say that, look, one of the tests will be if there is a gross violation of fundamental rights, then the litigant should not be told to go to the High Court. It appears to be a rational thinking, but there is other side of it. Today, I am not expressing my thoughts as a judge. I am expressing my thoughts as somebody who is student of law for the last 40 years. And therefore, ultimately, this will have to be decided by the judiciary, by the Supreme Court. But we have to consider the other side of it. Today, if you have a scenario that very rigid tests are laid down, that only if the case falls in one of these tests laid down, in one of the judgments of the Supreme Court, only in that case 32 jurisdiction can be invoked. Then it is possible to say that on our own, we are circumscribing such a jurisdiction vested in us. We are curtailing our own powers by laying down the test. So this is a highly debatable area where we'll have to seriously debate on this, whether Supreme Court should lay down the test. In fact, these three questions which are raised require a debate by jurists, members of the bar, judges and human rights activists. There is another criticism dealing with question number 3, or that is implicit in question number 3. The criticism is that why the judges of the Supreme Court or judges of any constitutional court do not have a uniform approach. I attended a workshop in one of the national law schools where one of the speakers said that why the judges don't meet after the court hours and try to adopt a uniform policy, uniform approach. The legal world is very complex. There is always another side to what is canvassed and what is argued. If the judges meet and informally decide to adopt a consistent approach, will such decision not compromise on judicial discretion and, more importantly, judicial independence? That's the question which will be asked. So it's not easy to say that you meet and have a common uniform approach. Perhaps it is because of these different opinions which are expressed by different benches that we are able to develop our constitutional law. Uniform approach may not, the diverse approach may help in developing the concepts in law. Of course, if you read academically, you will find that this great gift given to us by Dr. Babasaheb Ambedkar contains solutions to the problems. Very interestingly, if you see clause 3 of Article 32, it says, without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2 of Article 32. So, Parliament may come out with a law conferring jurisdiction which is exercised by the Supreme Court under Article 32 on the High Court. Of course, people who are sitting here, we are not able to deal with this issue because it is ultimately it will have to be left to the parliamentarians. But there is a solution provided that if somebody feels that the Supreme Court will be overburdened with the task of dealing with so many 32 petitions, there is a solution provided in clause 3 of Article 32. I think I have exceeded my time, but before I close, only one or two small things which I want to share. One is, when we complete 75 years of existence of our constitution, surely we, as part of the judiciary, must invite a debate on the enforcement of fundamental rights by the courts. How far we have been successful. Mr. Gupta referred to one of the speeches which I delivered. I mean the same thing, that this is the proper time to introspect and find out how far our courts have been successful in enforcing the fundamental rights or the rights forming part of chapter 3, which is the most important chapter in our constitution. I am very happy that Justice Gavai will not be the next speaker, but there will be a comedian who will come on the stage. And this is consistent with the policy of Leaflet, because Leaflet believes in publishing articles by my dear friend Raju More. So I expected this to happen. But speaking for myself, perhaps I feel that a comedian may be better commentator on Article 32 rather than the judges. So I take your leave and vacate the podium for comedian.
Thank you, Justice Oak, for such a comprehensive and a compelling appraisal of Article 32. And now, as you said, there is a comedian here. And the only thing I think we can all say is that none of us is responsible here for what he says. He is solely responsible for anything he says today. Please, may I invite Manu, please come.
Hello, good evening. Even though, please note the disclaimer, small disclaimer, even though I like being held in my life, please don't hold me in contempt today. Jai Bhim, I hope everybody has a seat, pun intended. Good afternoon, my name is Manu Abhishek. No, not that one. The judges got scared for a second that now I'm going to speak for hours and hours and hours and hours. No, okay. But I won't speak for hours. If I say that I take 5 minutes, I will take 5 minutes. Because as a junior lawyer, I don't get paid enough to speak more than that. A lot of senior advocates present here today. This is not a joke. Some of your juniors called me and they're like, can you please roast my boss? They're going to be there today. And I told them that this is not a roast. We are here to celebrate Ambedkar Jayanti. And what says Ambedkar Jayanti more than a typical upper caste brown boy named Manu being given the opportunity to be on the stage right now. But I'm an ally. So I did a lot of research before coming here. I had to read up a lot of recent judgments, a lot of articles. And I'm sorry I had to use Manu Patra for that as well. I'm sorry, Babasaheb, SCC is really expensive. An honorable judge, joke number 3 has been self-centered and redacted by me, nobody else. An honorable judge of the Supreme Court recently said that special connections are not necessary to succeed in this profession. And I completely agree with him. Because I don't think you need special connections, but very special connections to succeed in this profession. Let's talk about Dr. B.R. Ambedkar. On 21st February 1948, Dr. B.R. Ambedkar, who was the first Law Minister of India, wrote a letter to the first President of India, Dr. Rajendra Prasad, with a copy of the draft of the Constitution. And he has had such an influence that the trend is still going on. People are still writing letters to the President, but this time it's for scrapping of judgments and undermining the authority of the Supreme Court, but the trend is still going on. Thank you, Dr. Ambedkar. Dr. Ambedkar was a master in 64 subjects and proficient in 11 languages and received his doctorate from London School of Economics, but Guddu Pandit from Facebook.com could not clear his 9th standard exam, blames reservation for taking up his jobs. Where is casteism? It does not exist, says Guddu Pandit, who has a huge sticker which says Brahman on the back of his Mahindra Scorpio, and he only wants an upper caste Hindu wife according to his Shadi.com profile. In 2017, on the occasion of Ambedkar Jayanti, Twitter, currently known as X, launched an Ambedkar emoji as a tribute to him, and that was a great initiative at that time. And for this year, to give the tribute to the Indian economy, Twitter drove down its own revenue by 22%. Here's a fun fact. Canada's British Columbia province has recognized April as Dalit History Month. And in India, the month we celebrate Dalit History Month is the month before elections, which coincidentally is April. So happy Dalit History Month to everybody. Okay. As per my research, most of the Delhi High Court Bar Association office bearers barely include any Dalit representatives. The Delhi High Court Bar Association recently inaugurated a Starbucks in Delhi High Court as well. And since most of them represent all the four Varnas, they're thinking of opening a branch of Savarna Bhavan. Only veg food, bye bye mutton korma on Friday evenings. As I sign off, my anticipatory bail is being filed alongside. May I request the judges if I can say the censored joke, which I've censored myself, if I won't be held in contempt. Okay. Please. Okay. We are in the presence of the two of the most eminent judges of the Supreme Court, Justice B.R. Gavai and Justice Abhay S. Please give it up for them, please. I feel very fortunate today to be given this opportunity to speak before this, what is perceived as a very, very learned bench of the Supreme Court by lawyers, because I've heard that even senior lawyers are having a little trouble getting their matters listed before this honorable bench. Thank you. That's been my time. I'm Manu Abhishek, not that guy.
May I only say that with a sense of relief, we say thank you to Manu. Now, may I once again request Mr. Jaideep Gupta, Senior Advocate, to please give an introduction of Honorable Justice B.R. Gavai before his speech. Thank you.
I don't think Manu Abhishek is to take all the flack for the jokes, because I can assure you that there was a back and forth going on in our groups on what he can or cannot do. Our next speaker, Justice Bhushan Gavai, had a career as a public lawyer for 18 years and a judicial career of 20 years. To him, the Constitution of India is a transformative document that takes India from colonialism to democracy, from the order of the Queen to the will of the people, he said, and seeks to uphold justice, equality, and dignity for all its citizens. At the Harvard Kennedy School, Justice Gavai recently gave an expansive and comprehensive definition to the concept of judicial review, the doctrine that allows the constitutional courts of our country to review legislation and administrative action on the anvil of the Constitution. He said that this includes a duty to ensure that the political branches take appropriate course of action to adhere to constitutional requirements on a continuing basis. Article 32 being the fountainhead of the power of judicial review, we look forward to hearing from my Lord on the history and future of this article. Justice Gavai.
My esteemed colleague and my dear friend for last 40 years, Justice Abhay S, my esteemed colleagues, Justice Vishwanath, Justice Boyan, Justice Parrey, Justice Ravindra Bhatt, my colleagues from Delhi High Court, Justice Chakdar, Justice Tara Ganju, Justice Mili Pushkarna, Srimati Indira Jaising, Shri Chauhan, Shri Jaideep Gupta, Arif, Ayaz, Parrey, the learned senior counsel designated as well as non-designated, and those in the line, the members of the bar. It's really difficult to be in a reverse situation. Every day we listen to all of you and then pass short orders. But addressing such a elite gathering is somewhat difficult. Justice Oak was fortunate enough to having been given 3 questions by Anand. To me, he gave some ready material. But since today's function is to commemorate the 133rd birth anniversary of Dr. Babasaheb Ambedkar, and the topic is the origin and future of Article 32, I have decided not to touch his material and share my own views. After listening to another Abhishek Manu, we have Abhishek Manu every day. So, when today's Abhishek Manu said that he would be speaking only for 5 minutes, my brother said he should have said 30 seconds. Today we are here to speak on origin and the future of Article 32. So I'll be not referring to the pre-constitutional or pre-independent history of the rite of origin, but referring to the origin of Article 32 as in the Constitution. And with a great sense of pride, I must say that the credit of origin of Article 32 goes to none other than Dr. B.R. Ambedkar, whose 133rd birth anniversary we are celebrating today. Dr. Ambedkar was elected to the Constituent Assembly from the Bombay province after he had lost the elections from the West Bengal, now a part of the Bangladesh. And he said that he entered into the Constituent Assembly only to safeguard the interest of, I forgot the senior most member of the bar, Mr. Burli Bhandari. He said that his initial entry in the Constituent Assembly was only to safeguard the interests of scheduled castes and scheduled tribes and backward classes. On 13th of December 1946, Pandit Jawaharlal Nehru, he presented the Objectives Resolution to the Constituent Assembly. The Objectives Resolution, which is now considered as a foundation of the preamble. And within 4 days, Dr. Ambedkar was called upon to address the Constituent Assembly on 17th of December 1946. Dr. Ambedkar pointed out various lacunas in the Objective Resolution. He said that coming from a person like Pandit Jawaharlal Nehru, a socialist, a sworn socialist, there are various lacunas in the Objectives Resolution. I would not refer to his entire speech, but I will only quote a part of his speech which can be said to be an origin of Article 32. I quote Dr. Ambedkar. The resolution suffers from certain other lacunas. I find that this part of the resolution, although it enunciates certain rights, does not speak of remedies. All of us are aware of the fact that rights are nothing unless remedies are provided, whereby people can seek to obtain redress when rights are invaded. I find a complete absence of remedy. Dr. Ambedkar little did know that in a short period he will be on the drafting committee of the Constitution, and that one day he will have to also chair the drafting committee. And therefore, his contribution to Article 32 finds its base in the speech of 17th of December 1946. The drafting committee, under the letter signed by Dr. Ambedkar, to which another Abhishek Manu referred to, presented the draft constitution and it was thoroughly discussed. The discussions with regard to Article 32, which in the draft article was Article 25, were commenced from 4th November 1948 till 9th of November 1948. I will be failing in my duty to refer to some of the speeches in the Constituent Assembly which discussed then Article 25, which is now Article 32. Qazi Syed Kamiruddin had moved a motion to postpone the consideration of Article 32, that is 25, till emergency provisions were considered, because the articles dealing with the emergency had provisions for suspension of the rights under Article 32. Dr. Ambedkar had opposed the motion, arguing that Article 32 could be amended at the time of discussing the emergency provisions. The motion was defeated. It will also be apt to refer to the speech of Mr. Anand Iyengar, one of the famous of the Constituent Assembly. He quoted, Mr. Vice President, sir, the Supreme Court, according to me, is the supreme guardian of the citizens' right in the democracy. I would even go further and say that it is the soul of democracy. The executive, which comes into being for the time being, is apt to abuse its powers. And therefore, the Supreme Court must be there, strong and untrammeled by the day-to-day passions, which may bring a set of people into power and throw them out also in a very short time. Sir, I agree with my predecessors who have spoken that this is the most important article in the whole Constitution, as it is the guardian of the people's right. H.V. Kamath, who also later on became a Speaker of the Parliament, stated, and I quote, the President may by order declare that the rights guaranteed by Article 25 of this Constitution shall remain suspended for such period not exceeding beyond a period of 6 months after the proclamation has ceased to be in operation, as may be specified in such order. Is not clause 4 liable to be misconstrued when it is read with Article 280? Does Article 280 cover all the fundamental rights? Does it mean, sir, that even such rights as rights of untouchability, religious and cultural rights will also be suspended? Dr. Ambedkar also had to deal with the other speeches, and in reply to Article 25, he states, and I quote him, I know of no constitution which gave fundamental rights, but which gives them in such a manner as to deprive the state in times of emergency to protect itself by curtailing the rights of the individual. The only right that would be suspended under the proclamation issued by the President under an emergency are contained in Article 13. All other articles and the rights guaranteed thereunder would remain intact. None of them would be affected. If I was asked to name any particular article in the Constitution as the most important, an article without which this Constitution would be a nullity, I could not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it, and I am glad that the House has realized its importance. The Constitution has invested the Supreme Court with these rights, and these rights could not be taken away unless and until the Constitution itself is amended by means left open to the legislature. Dr. Ambedkar further suggested with respect to the emergency provisions that all they do it to suspend the remedies. And he states, I quote him, I prefer the British method of dealing with rights. British jurisprudence insists that there can be no right unless the Constitution provides a remedy for it. It is the remedy that makes a right real. If there is no remedy, there is no right at all, and I am therefore not prepared to burden the Constitution with number of pious declarations which may sound as glittering generalities, but for which the Constitution makes no provision by way of a remedy. I am very glad that this House has seen that the remedies that we have provided constitute a fundamental part of this Constitution. Sir, with these words, I commend this article to the House. That is how Article 32 came into the Constitution. We have seen that in last 75 years of the working of our Constitution, Article 32 and also Article 226 have been used by the Supreme Court as well as the various high courts for the transformative justice that the Constitution is a weapon for. Dr. Ambedkar always used to say that Constitution is a weapon for achieving bloodless revolution. He said that the Constitution is not a book for lawyers, but a way of life. And in the last 75 years, we have seen that our superior courts, the high courts and the Supreme Court have utilized Article 32 and 226 in a large way so as to achieve the social and economic justice as conceptualized by the framers of the Constitution. Various rights have been construed to be fundamental rights. In the case of Rashid Ahmad versus Municipal Board, Kairana, right to business under Article 19(1)(g) was considered to be a fundamental right. Right to life under Article 21 has been received such a vast and expansive interpretation by judicial interpretations. Many of the rights which were not conceptualized at the time of inception of the Constitution have been called out to be the fundamental rights by judicial interpretations. As held in Maneka Gandhi, that Part 3 is not exhaustive, but anything which flows from the trinity of Article 14, Article 19 and 21 could be considered to be a fundamental right. We see that various rights like the right to food, right to potable water, right to shelter, right to sleep, right to live in a pollution-free environment have all been considered to be fundamental rights by judicial interpretation. The right to education, even before the Constitution was amended to bring in Article 21A, was considered to be a fundamental right in Unni Krishnan and Mohini Jain. Right to health has been considered to be a fundamental right in Parmanand Katara as well as Paschim Bengal, Kheti Mazdoor Sangh. Right to life under Article 21 has been held to be not to live a life like animal, but right to live is the right to live with a human dignity. Various other rights like the right to privacy, right to share a partner have all been construed by the Supreme Court by judicial interpretation. We have been seeing that in the case of T.N. Godavarnam versus Tirumal of T.N. Godavarnam versus Union of India, the court has been using a continuous mandamus, a writ of continuous mandamus, so as to protect the environment, passing orders from time to time to protect the environment. Millions of trees, vast stretches of forest have been saved on account of the orders passed by the Supreme Court. Due to various orders passed in M.C. Mehta versus Union of India, the polluting buses, diesel buses from Delhi were thrown out of Delhi. The polluting industries from Delhi were shifted out of Delhi. In M.C. Mehta, the Taj, which is considered to be one of the 7 wonders in the country, is being saved from the pollution on account of the continuous monitoring by the Supreme Court in the case of MC Mehta. In Bandhuwa Mukti Morcha, the Supreme Court came to the rescue of the laborers, the captive laborers who were working in mines and deprived of the basic amenities, health, water, food. In the case of Vinit Narayan versus Union of India, again in a petition filed under Article 32, the Supreme Court issued various directions which included the manner and working of the CBI director to ensure that the independence of and prime agency of the Central Bureau of Investigation was ensured. The court held that right to have an impartial and free investigation in such important matters was also a right constituted by the Supreme Court. In the case of Vishaka, the Supreme Court issued various directions in order to protect the plight of the working woman from the sexual harassment. And there are various other cases on account of paucity of time, and before Warisha comes on the dais to stop me, I will have to conclude. The 20 minutes are, I think, almost over. With her permission, if I am given 5 more minutes. A reference was made to the speech of Dr. Babasaheb Ambedkar on 25th of January 1949, when he concluded the discussions on the draft constitution. Dr. Babasaheb Ambedkar in that speech gave various warnings to the country. I'll only refer to one of his, to which one of the earlier speakers, the president of the Society for Constitution and Social Democracy, referred to. I think it's one of the most important aspects. It is the soul of the Constitution. It provides us a vision as to how we should work in the future and as to what is the ultimate goal of the Constitution. I quote, "The third thing that we must do is not to be content with a mere political democracy. We must make our political democracy a social democracy as well as economic democracy. Political democracy cannot last unless there lies at the base of it a social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity as the principles of life. These principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a unity of trinity in the sense that to divorce one from the another is to defeat the very purpose of the democracy. Liberty cannot be divorced from equality. Equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. Without fraternity, liberty and equality would not become a natural source of things. It would require a constable to enforce them. We must begin by acknowledging the fact that there is complete absence of two things in the Indian society. One of these is equality. On the social plane, we have in India a society based on the principle of graded inequality, which means elevation for some and degradation for others. On the economic plane, we have a society in which there are some who have immense wealth as against many who live in abject poverty. On the 26th of January 1950, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one value. In our social and economic life, we shall by reason of our social and economic structure, continue to deny the principle of one man, one value? How long shall we continue to live life, this life of contradictions? How long shall we continue to deny equality in our social and economic life? If we continue to deny it for long, we will do so only by putting our political democracy in peril. We must remove these contradictions at the earliest possible moment, or else those who suffer from inequality will blow up the structure of political democracy which this assembly has so laboriously built up. This is what he had said 74 years back. Dr. Ambedkar always said that I am not a pessimistic person, but I am an optimistic person. He was criticized that part 4 is nothing else but a post-dated check on a bankrupt back. He said that I agree with the criticism that it is a post-dated check, but I disagree with the criticism that it is on a bankrupt bank. He said that I am sure that one day the bank of my nation will be so able that this post-dated check which I am giving today will be encashed at some point of time. And we have seen that in the last 75 years, the country has marched ahead towards achieving the social and economic democracy. All the three wings, maybe the parliament, the legislature, the executive, the judiciary, have always acted in the furtherance of achieving social and economic justice. Various enactments for bringing social and economic justice, like prohibition of untouchability, labor welfare laws, ceiling laws, tenancy laws, have been enacted by the parliament, and right from the judgment of Chauhan Bharti, which we celebrated the Golden Jubilee last year, all these enactments have been upheld by the Supreme Court since they were in furtherance of the distributive justice. They were in furtherance of bringing down the economic and social inequalities and bringing in social and economic equalities. Like Indira Jaising said in a speech, that what is see today is only because of the Constitution of India. I fully agree with her. We have had a woman president, a woman prime minister, a woman speaker of the Lok Sabha, and presently a woman president who also happens to be the first scheduled tribe president. We have two presidents who belong to scheduled caste. We have a speaker of Lok Sabha who belongs to scheduled caste. We have had many chief secretaries, director generals of polices in the country who belong to scheduled caste, who belong to backward classes. As I had said on the 28th of January, on the occasion of 74th anniversary of the Supreme Court, that it is only because of the Constitution of India and Dr. Ambedkar that a person like me, who started his schooling in a semi-slum area, school run by a municipal school, could make it to this position. And therefore, the journey of Article 32, Article 226 on the Constitution has been in furtherance of the dream of our constitution makers of achieving social and economic justice. No doubt that a lot needs to be done, and therefore, when we speak of the future of Article 32, and not only 32, we'll have to speak of the future of Article 32, the future of Article 226, and the future of the Constitution of India. The concept of diversity, equity, and inclusiveness, which has been so finely engulfed into our Constitution, is the one which will have to be our aim. We'll have to use these articles, we will have to use this Constitution as an weapon, as dreamed by Dr. Ambedkar, to achieve social and economic justice, so that the inequalities in this country are totally diminished and we achieve the dream of our constitution makers of the achieving an illegal society. Thank you very much for giving me an opportunity to be with you and sharing my views. I once again thank Anand, who has been after me for last 1 year for this event, and I apologize. My apologies to Warisha that I had to overstay for a couple of minutes. Thank you very much.
Thank you, sir. Not only for such a masterful exposition on Article 32, but for such a heartfelt tribute to Dr. Ambedkar and his ideals and everything that he did, not only for the Constitution, but for building India as a modern nation. So thank you. It was a very heartfelt speech, and thank you very much for that. Finally, I would like to, before the questions, I would just like to invite Mr. Anand Grover, Senior Advocate, to give a few closing remarks. After that, we will get into the Q&A with the honorable judges. Oh, all right. Okay. So I seem to be making quite a few mistakes here. Okay. So what I will do is I will take 2 or 3 questions together. I will not read the questions. I will request the persons who've given the questions to introduce themselves and read the questions themselves. Can I first call upon Harshit Anand? Mr. Harshit Anand, can someone pass the mic to him? Please ask your question. And please tell us if it is addressed to both the judges, how you would like it answered.
Good evening to everyone. Good evening, respected judges. My question is particularly in relation to personal liberty petitions, which come directly to the Supreme Court under Article 32. And like Justice Oak mentioned in his speech, there are certain competing values which are at play here. For example, if the Supreme Court starts to entertain these petitions generally, then questions such as top heaviness of the court and also about the general distrust of the criminal legal system, these are the questions which come to the fore. And on the other hand, there's another competing core, something which is a core ideal of the freedom of the question of the core ideals of fundamental rights. That is, a person should not be illegally detained even for 24 hours if the detention or the arrest is illegal. So my question to both the judges is that in a polyvocal Supreme Court where outcomes generally usually depend upon the bench to which the petition goes, how do we, or is it even possible to reach a viable framework which can instill some sort of predictability or certainty as to how and in what manner these personal liberty petitions are entertained or heard on merits by the court? Thank you.
Thank you. Can I now request Mr. Rohit Kumar to ask his question, advocate on record?
This is a question regarding the technicalities involved in filing the 32 and 226 petition, sir. So what happens, there are instances when somebody sent a letter petition to the Constitution Court, but it's actually sent back to them stating format errors or some technicality involved, and sometimes the litigants write it in a Hindi or colloquial language, and the registries ask them to send it in pure English. So, there are instances where either the essence of the petition get infatuated, or it has not been affected or heard in a proper time frame. So I just want to hear your views on some technicalities involved in filing the Article 32 petitions and the scope of letter petition in this.
So maybe we can start with these 2 questions and then I'll put the others.
Normally when we sit in benches, it is the privilege of the senior just to speak. But I am making a diversion from that rule. I am taking liberty with my friend. The first question, I think I dealt with that question in my speech. The question is, different benches are taking different view and how this can be prevented. The answer is very simple. The answer is that we need such diversity when it comes to judicial views. I'll give an example. Gopalan was corrected. Gopalan was corrected because we don't speak in one voice. I mean, after passage of time, we change our views. ADM was corrected later on. So this is a continuous process. Today we say something in the court, or we decide a case. That is always open to correction. And therefore now you see review, the curative petition, there can be reference to larger bench. So I don't think what we expect from the judiciary can be achieved. Because law is not like a mathematics, 2 plus 2 is 4. There will be views and views on one issue.
This is Nariman has written a book, the dissent which became subsequently the majority view.
Thank you, sir. Sir, the second question, sir, may I now request you to answer the second question by Mr. Rohit Kumar? Anything on that?
No, because regarding the procedure of registry, we will not be in a position to answer.
Yes. Sir, not that, all right.
He said the technicalities in filing of the...
No, sir, not that one. Yes, sir. Sir, can I... Yes. Sir, can I ask this question that Mr. Muhammad Talha Hassan has written? He has posed this question for both the judges. Dear respectable judges, as we have seen the habeas corpus petition filed by politicians detained in the aftermath of Article 370 abrogations not being heard for a prolonged period of time, has the Supreme Court, how will Supreme Court deal with these issues of personal liberty?
No questions with regard to pending matters.
Question, Mr. Prashant Padmanabhan, can you ask your question, but please keep it very brief?
We have heard about the past and present. What about the future of 32? We have heard the speech of the Chief Justice recently on artificial intelligence and the challenges it poses. So, to that, if such a situation comes, when there are manipulations or biases in algorithms and newer challenges before Supreme Court, in your tenure, will you be laying down the law by invoking Article 32?
No, I didn't get your question.
In future, there could be challenges on account of technology. Like we have heard about the past and present of Article 32. What about the future? There may be newer challenges on account of use of artificial intelligence and newer technology. Some software we have seen that all over the world, that was Pegasus, and these type of challenges may come up. Yes. So we have heard about Chief Justice Chandrachud's view on that. Whether you will be taking it forward in your tenure and whether Article 32 will be invoked to lay down the law.
No. In any case, artificial intelligence cannot be a substitute for human mind. Otherwise, you won't require judges. You feed the facts to the computer, then applicable law, and then get a judgment. And what will be done in the future, it all depends on the cases that will come up for consideration. You can't anticipate what is likely to happen 2 years later or 3 years later.
Thank you, sir. Mr. Anirudh Tyagi, do you want to ask your question? Please keep it short.
We have seen the jurisprudence with respect to public interest litigations. This is the orientation by the Supreme Court judgment. There is no statutory backing behind the public interest litigation petitions. So how does my lord see the future of public interest litigation jurisprudence as far as, because we have seen the parliament overturning the judgments of the Supreme Court. How does the jurisprudence with respect to public interest litigations, my lord, see in future? There are chances that the parliament may overturn that also. Yeah.
No, one correction. You said that public interest litigation has no statutory backing. It has constitutional backing.
A final question from Miss Medha Chandra. She's a second year law student. Are you still here? Do you want to ask your question? Please.
My question is open to both honorable judges. Mr. Gopal Subramaniam, sir, in his chapter on writs and remedies in the Constitutional Handbook, said that two features of the Indian legal system have played a key role in the weakening of constitutional remedies in India. One of them, he pointed out, was the growth of tribunals in India. And while the Supreme Court has also rightly observed that if tribunals are vested with the same powers of the High Court but don't have the same independence, the impact that it is having in the current legal scenario, if you could shed some light on it and what could be the way forward from here. Thank
We will request Mr. Gopal Shankar Narayan to answer that question. He is very much here.
Okay. I think one last question, and then we'll move to the next part of the program. It's an interesting question. It says, "Your Lordships, our preamble situates the norm of dignity of the individual as the basis of fraternity. In the light of this norm, could you please express your ideas on whether individual liberty can be placed to the test of subjective social morality?" It's the person does not name himself. He just says student, National Law University, Delhi. So, any answers? I think if I ask any more questions, I'll also have to move my anticipatory bail. So I think, yes, no. No, my lords have been very gracious and have not only answered all the questions very frankly and honestly, but have also told us many new things that we did not know, both about the system and about Article 32, and we are very grateful for that. I now invite Mr. Anand Grover, Senior Advocate, for closing remarks.
Thank you, all of you, for attending. I must say, when I asked Justice Oak and Justice Gavai, they were not only ready but willing to come and speak. I'm really grateful to them for being here. But most importantly, when I ventured to ask them whether they would answer questions, they were more ready and willing. And I'm really grateful for that. You know, I have the great opportunity of traveling all over as the UN Special Rapporteur on the right to health. And one of the most common questions, especially in the developing countries, was how is it that in India, which is full of diverse communities, religions, castes, and they don't know much about castes, except in Japan, where they have an old caste system, which I found much to my surprise. How is it that you have survived? And I used to answer always that it is because of our constitution and our great constitution makers, including Dr. Babasaheb Ambedkar. And I've always been very proud of that. But I'll tell you, today the questions that are being asked to me is what is failing in India. That is the sad part of it. But I always tell them about the preamble, which actually encapsulates the vision and the soul of the Constitution. And as Warisha said, what is specific about India, because remember the French Revolution had liberté, equalité, fraternité. And fraternity is emphasized much more through dignity, which is the soul in that sense, and plurality. That's what's special about India. Plurality, dignity, etc. And we have held this country together because of the Constitution. And one of the most important things is that the judiciary must be independent. And who makes sure that the judiciary is independent? We believe in the leaflet that it is the bar which actually supports that independence. If the bar is weak, you cannot guarantee the independence of the judiciary. And the judiciary's independence is very, very, very important, not only in our system, all over the world. And there are cracks within the judicial system all over. Roe versus Wade, I said in University of Northwestern in Chicago, was in fact not a judicial decision. The same judges, when they were asked in the Senate about Roe versus Wade, they said they actually would uphold it. They are the ones who actually overturned it. This problem occurs all over. So we believe in the leaflet that the bar has to be strong. What does it mean? The bar, as Ms. Jaising has said repeatedly, has had a historic role in protecting the independence of the judiciary. This means when the judiciary does something good, we have to support it. But when things are falling, we have to speak up. Not in a venomous or a hostile manner, but as Justice Oak emphasized, it has to be constructively critical. And that is the mode of this meeting. Our purpose was to start a dialogue between the bench and bar so that we can actually have an honest, critical debate on a number of issues. This is the first of these events, and we hope with your support, with minimal amount of money, we can actually have more meetings in different high courts and in the Supreme Court. And we hope that sitting judges would be willing to come and speak and actually answer questions. So I want to thank all of you for being part of this initiative. If you are critical, it's very good. I always tell all my students, I happen to teach in a number of law schools in the US and here, and I always tell them, if you are not critical, you don't be in my class. So I want to tell all you members of the bar, please be critical, but constructively so, as Justice Oaks emphasized. Thank you very much. We have the last part of the event, which is to give a small gift to the learned judges and members, and that actually is a very interesting gift. Where are the gifts? And we have an interesting gift, by the way. It's a t-shirt which will be worn by the judges, not now, but at home, with a preamble on top, with a preamble printed. And we have a number of t-shirts for that. So I hope you can do it. And we also want more meetings, as I said. And I've asked some of the judges who are present here that they would actually be able to help in this effort. I hope you'll support us, because it's very important at this juncture that the bar and the bench actually interact in a dialogistic manner so that we can move forward our constitution and protect it from any kind of invasion. And it can happen in any government. Please understand that. And we cannot afford to have that. If the t-shirts are ready, we can give it to them.
Mr. Dr. Chauhan. Mr. Jaideep Gupta, Senior Advocate. And Mr. Arif Ayaz Parrey, the Editor-in-Chief of the Leaflet. I finally invite Gursimran to give the vote of thanks for the evening.
Good evening, everyone. Thank you very much for joining us this evening. I would first like to thank our guests for this evening, Justice Gavai and Justice Oak. This event was co-organized by the Leaflet in collaboration with the Society for Constitution and Social Democracy. This event wouldn't have been possible without our co-founders, Ms. Jaising, her team, Rohin and Paras, Anand Grover, and of course, Sunil from Society for Constitution and Social Democracy. I would also like to thank Dr. Chauhan for his opening remarks, Warisha and Jaideep for their introduction, the Leaflet's editor, Arif, and of course our very own Abhishek Manu. I mean, of course, not that guy. And Avi, Astha, Nipun, Akshata, and their respective team members, Lalit for the logistic support, Vikas for media support. I hope you enjoyed this evening. Please look forward to many more events by the Leaflet because we believe in Constitution first. Thank you so much.